Good evening, ladies and gentlemen. As we all know, that Institute of Social and Cultural Studies, as an autonomous organization, has been interacting about various historical perspective, cultural aspects, development ideas through national and international events, publications in collaboration with ministry and private forums for more than a decade now. Thus, as a part of Institute's endeavor, it has taken this initiative to address the impact of COVID-19 on the judiciary system of West Bengal over a webinar today on West Bengal's judiciary in face of COVID. We are very privileged to have senior advocate Jayanto Kumar Mitti, a barrister in law and former Advocate General of the state, as a moderator for today's event. Good evening, sir. It's a
Very good
privilege
evening
to
to you.
have you. Uh,
It is a
yes,
pleasure
sir.
for me to join
And
on.
amongst the distinguished speakers, thank you. Amongst the distinguished speakers, we have Advocate Tamal Kanti Mukherjee, Public Prosecutor, City Session Court, Kolkata. We welcome you, sir. Thank you so much for being with us. We have Advocate Deepan Kumar Sarkar, Advocate, High Court, Calcutta, and Retrainer, Prison Reform Program, Commonwealth Human Rights Initiative. We welcome you, sir. Deepan, sir. It's a privilege to have you. We have Advocate Orindam Mitro, Additional Government Leader, Senior Panel, Siliguri, former Chairperson, Siliguri Municipal Corporation, Honorary Lecturer of Indian Institute of Legal Studies. Thank you, sir, for being with us. And of course,
Thank you
we
so
have
much,
a
Vivek.
very eminent, yeah. And amongst the fourth speakers, we have a very eminent and young advocate, Shayok Chakraborty, who us from Calcutta High Court. We welcome you, sir. Thank you for being with us, and thank you so much for helping the institute to, to design this particular webinar. Thank you, Shayok.
Thank you. Thank you.
Before we proceed, gentle request. Yeah. Before we proceed, gentle request. Participants who are interested to seek an e-participation certificate, please do write to us post-webinar. Participants who have already written to us need not write. E-participation certificate will be sent to you in your given email ID. And after all the deliberations, we would look forward to an interactive session. For your question to be answered, please mention the speaker you want your question to be addressed. Mention the question and send it us through chat box. Now, I would like to request the moderator, Senior Advocate Jayanto sir. Jayanto sir, please take it forward from here.
Good evening, everybody. Um, it is my pleasure to be with all of you. I suppose there will be many young faces who will be greeting me. I can see, of course, amongst the speakers, everybody is younger to me, no doubt about it. But two or three of them are very young. I'm very glad that they will be participating in this particular discourse, and I shall be very much interested to hear what they say. My first thing is that I shall thank the Institute of Social and Cultural Studies for having organized this particular function. This particular seminar is very important in the present day scenario. Uh, all of you are fully aware that we are passing through a very unusual time. A time, well, none of us could ever dreamt of, even in our worst nightmares. The pandemic has taken its toll in our daily life, and even after 6 months of the lockdown, it has not loosened its vice-like grip. No doubt it is not the best of times. But since I am not a pessimist, I hope that it is not the worst of times. It is undoubtedly not the spring of hope, but I am hesitant to consider it to be the winter of despair. As all of you have experienced, the pandemic has brought about a complete upheaval in our daily existence. And we have been forced to adopt the new concept of social distancing, which I'm afraid is going to stay with us for a long time to come. That has caused far reaching changes in the justice delivery system also. I foresee that even after the lockdown has been withdrawn, our judicial system will not remain the same and will undergo large scale changes, which we, the lawyers, the judges, and the litigants, are not yet ready to accept. In a recent seminar in Delhi, Justice D.Y. Chandrachud of the Supreme Court said that judiciary shall embrace the use of e-governance. He further said that unprecedented pandemic has brought about the adoption of technology by the courts. And now the profession is focused on how the technology should be adopted. Now, in a situation like this, it is very important that we should discuss about our future course of action. This is not only for the lawyers. Somebody should put the microphone in mute. Otherwise, there is disturbance. Now, in today's deliberation, I would like to set the tone of the discussion in the light of the above observation of Justice Chandrachud. I must remind the speakers that this evening we are not discussing the adoption of technology in the Supreme Court or the High Courts. We must learn from the speakers of today the problems, the difficulties, and progress in the adoption of technology in the justice delivery system, in the district courts, in the courts exercising criminal jurisdiction, in the consumer courts, industrial courts, the administrative tribunals, and various other judicial fora in West Bengal, which are being approached by litigant public, for obtaining judicial remedy. The learned speakers, I hope, with their experience in the field of law, will surely enlighten the audience this evening the problems and shortcomings they have been facing in the justice delivery system at this time of COVID, and the measures they would suggest to overcome such problems. However, I shall request you not to confine yourselves only to the topic of online hearing, because I am firmly of the view that virtual hearing in a court of law can never be a substitute for actual hearing. Physical hearing is an essentiality in my view, and virtual hearing can only supplement the physical hearing. You may agree with me or may not, but this is my firm view, and particularly this physical hearing has been ingrained in my system during my practice for the last 50 years or more. So I would like the speakers also to deliberate on how and when they visualize in future the commencement of actual courts, and whether they could suggest any special procedure to be adopted to safeguard against the contagion of COVID. Now, I will, in this connection, I shall only refer you lastly, before I give over the microphone to you, that I must inform you that the Delhi High Court has very recently issued a notification containing the standard operating procedure, which is called SOP, for resumption of physical functioning of the High Court at Delhi with effect from the 1st of September 2020. The SOP, as I have seen, contains very stringent restrictions on the entry and admission of advocates, their clerks, and the party, if appearing in person, in connection with the hearing of matters in court. If any of the speakers has any suggestions on this aspect, I would like him to share it with us. Now, with these preliminary words, really, you have not come to hear me. You have come, and I have come here to hear the speakers who are going to put in their very valuable suggestions in course of this discourse this evening. So, I would now first call upon our first speaker, Mr. Tamal Mukherjee, Public Prosecutor, City Sessions Court, Kolkata, to express his views on the subject. Mr. Mukherjee.
So very good evening, sir. I fully agree with you what is said just now regarding the virtual hearing and the physical hearing. So since 23rd March 2020, our country has faced an unprecedented disaster in form of a deadly pandemic that swept through the world and infected millions of people and has caused innumerable deaths. What makes COVID so deadly is the fact that there is no known cure or vaccine against it today. The only
There,
remedy
sorry,
available was
excuse me,
lockdown.
Mr. Mukherjee. I think there is some disturbance in this. Uh, I would ask Ms. Roy to look into this because I can't hear exactly what he is saying. Yes, Mr. Mukherjee, please continue. And you put the microphone near your mouth. I think that would be better.
You hear me now? Hear me?
Yes, it is better. Please. Sorry to have interrupted.
COVID deadly is the fact that there is no known cure or vaccine against it this time. The only remedy available is lockdown of all missionaries in the country to people from coming in contact with each other. The government of India had enforced a nationwide lockdown, barring a few essential sectors. All working and offices were closed with immediate effect. The boards of India were amongst the institutions that completely complied with such directions. The problem is that we have never faced such situation earlier. This is something very new. This thing has happened today, which we are not really accustomed. So, for the virtual conversations or the virtual hearings are concerned, it is sometimes very difficult for us to continue or to communicate. Most of the time, at the time of hearing, we have been facing that there is a link is doing something problem by which we cannot communicate to each other because there must be the courts to hear both the lawyers from defense and prosecution at length. But sometimes we can feel that during the course of hearing, we just cannot hear each other. That is the whole trouble we have been facing right now. And one of the institutions, a pillar of democracy, being the judiciary, was to obey to this decision for public policy and welfare. As a result, overnight, the functioning of courts had ceased and were closed for the time being, when it became evident that the cure for the virus was not available, and the lockdown was the only solution, and was to continue. The judiciary had to improvise a solution to deal with massive number of undisclosed cases and huge number of cases which were impending. I mean to say, if you can just compare with my court, where I have been practicing city court as a public prosecutor, we are facing the problem each and every day. Because most of the cases, I find is due to the lack of link and all, we have to send our people, our lawyers to the court, and sometimes it's getting physical hearing also. So we are really rather confused because if the link cannot be given us and we cannot continue it through virtual conversation, we have been facing a lot of problems these days. So the fact that the judiciary was unable to distinguish or maintain the number. I'm sorry. The actual problem is remaining that what is it we have been facing? Just I told you. The thing is that we also indicate the matter before the learned court in several ways and several times that either you adopt this league system by which the people, the lawyers, and the litigants should should follow that. But unfortunately, that cannot be done in our practical life. I don't know what is going on in High Court, but the lower court we have been facing a lot of trouble here. That is the whole thing to be discussed, and I want to say like that. That's all.
Well, it seems that Mr. Mukherjee, who is very much conversant with the goings on in the district courts and in the courts exercising criminal jurisdiction, apparently the lawyers and as also the judges are facing difficulties because of most probably the link failure, and in course of hearing the link break. And this is the main point that Mr. Mukherjee has put forward before you. And also he says, and which is very important, he says sometimes it is necessary for the lawyers to come to the court, and some of the lawyers are also doing it from their house. So it is all very confusing when there is a mixture of actual court and virtual court. So this is the problem that the courts of criminal jurisdiction are facing, and the lawyers particularly are facing this problem. I suppose this problem is bound to happen unless we become conversant in the matter of use of these distant communications. Unless we are conversant with the technology, ultimately perhaps this problem is going to continue. So this is what Mr. Mukherjee has highlighted, and this is what he has. I will request those who are coming afterwards to speak, to try and see if this problem can be sorted out. This problem which Mr. Mukherjee has highlighted before you. Now, our next speaker is. Our next speaker, the second speaker is Mr. Dipon Kumar Sarkar, Advocate High Court. Is a very powerful speaker. I have heard him, and I'm sure that he will be able to throw some light on the subject. Yes, Mr. Sarkar.
Thank you, sir. I hope I'm audible.
You are very much audible.
Yes. I would also request all the respected participants, if they could mute themselves. I think that will enable both sir to hear what is being said, and also will enable your hearing as well. With that, sir, thank you very much. A very good evening to all present, including revered seniors from the bar, such as Mr. Jayanto Mitra and Mr. Taman Mukherjee. Now, even in usual course, problems in any country are not new. Now, the moment we try and solve one, 5 new pop up, be it in government, governance, society, health, development. Basically, the problems encompass all facets of society. Now, as we know, society is dynamic, and so are its multifarious challenges. It is like a constant tug of war between problems and solutions, so to speak. But the proposition I'd like to put forward here is that ultimately the solace is in mitigation, not absolute annihilation, because that is sometimes simply not possible. And at the center of it all is the common man. His sorrows, his problems, his development, they form the cornerstone of all beneficial endeavors of the state. Now the question is, who undertakes this endeavor? Now to answer this question, one would have to go back to the source, the fountainhead, which is our constitution. The constitution is a set of the most important rules and common understandings in any given country that essentially regulate the relations among the country's governing institutions. Now, the Indian state has 3 pillars: the legislature to formulate the laws, the executive to implement the laws, and the judiciary to interpret the laws. Now, it is also the judiciary which, in the course of interpreting the laws, upholds it for the benefit of the common man and the country alike. Therefore, its role vis-a-vis the common man is indispensable. Every person and every citizen, including citizens in this country, are guaranteed certain fundamental rights by Constitution, such as the right to equality under Article 14, the different rights to freedom, under Article 19 and the right to life and personal liberty under Article 21. This is apart from various other rights, entitlement, and other privileges which other laws give us. Now, what happens when any of these rights are violated? The aggrieved person approaches the court for justice. Now, his problem may be a private one, maybe a dispute over land with a neighbor, or an impending eviction by a landlord, or it may involve the public laws, denial of pension, acquisition of land by the state, or an unreasonable restriction on his business, or for what he believes to be an illegal arrest. Now, for every such grievance, his final destination is where? The court of law, be it a court of a magistrate or the Supreme Court itself. Now, that is why the right to access justice or right to have access to justice is an inalienable part and parcel of one's right to life and personal liberty under Article 21. Now, it is beyond question that one of the fundamental pillars of the rule of law in a state is its capacity to deliver justice to its people. And the condition precedent is to foremost ensure that there is a robust foundational framework for access to justice. However, as we all very well know, systems are not perfect and sometimes the problems are insurmountable. Now, since we are concerned with the situation in West Bengal, I shall try to be more specific. Now, last year, the Tata Trust, along with various other civil society bodies like the Vidhi Center for Research and Commonwealth Human Rights Initiative, they released an India Justice Report, 2019. The report analyzed, collected data from the governments, different state governments across the four pillars of justice: judiciary, police, prisons, and legal aid in 18 large and mid-sized states. And Bengal was ranked 12th out of 18, and in judiciary we were placed in the bottom half. Now, what are the problems which were seen in this report? The problem was that of creation and upgradation of infrastructure, where Bengal was ranked 10th out of these 18 states. It was seen that the spending in judiciary for the state had not increased. There had been an increase in the vacancies in the High Court and, more importantly, in the subordinate courts, which was also a cause for concern. Now, it found that Bengal's per capita spending behind the judiciary from 2015 onwards was among the least in the country, while the population per High Court judge in Bengal was among the highest. However, not to be pessimistic, one comforting statistic was that Calcutta High Court was among the few high courts in the country which reported a case clearance rate of over 100%, which means that the number of cases being disposed of was higher than the number of cases filed between the last 8 years or so. Now, however, a large number of cases in subordinate courts as well as the High Court have remained pending for more than 5 years. Now, being in litigation, as any litigant will tell you, is, in the words of T.S. Eliot, being in streets that follow like a tedious argument of insidious intent to lead you to an overwhelming question, oh, do not ask, what is it? Now, therefore, the need for infrastructural development, enough courts, enough judges, adequate staff, adequate connectivity has always been there. The problems of funding have been equally acute. No one can really be blamed for this because it is just the state of affairs, which requires a constant endeavor on the part of not just the state, but all stakeholders. Now, coming to the situation of caused by COVID. Now, this outbreak of the pandemic and its effect on society has been unforeseen and is certainly unprecedented. Now, instantly, the entire world has been turned into one large prison, so to speak. Offices have been shut, governments have retreated, people have been rendered jobless. There's a public health emergency of a scale no one could have imagined. And of course, the judiciary has been affected too. Courts have been shut. The judges cannot visit courts and sit in courtrooms. Lawyers cannot visit the courts to advise or argue for their clients. In other words, the entire justice delivery system has been virtually rendered static. Now, here I'd like to quote from a very recent judgment of our High Court, where their lordship sitting in the division bench very eloquently observed, and I quote, now, there are constitutions which go back several centuries and others, like ours, several decades. At the time that the people of India gave the constitution to themselves, Man had not broken into space, technology had not progressed to metamorphosing the entire planet into one big global village, and communication had not extended its sometimes eerie tentacles so wide that almost no human or human activity is beyond its invasive bandwidth. Further on, the court observed that it is difficult to perceive that the framers of the Constitution would have foreseen the remorseless antiques of the modern terrorist or the dangers presented by an invisible virus. Though the Constitution is flexible in allowing room for exigencies without spelling out every species of impediment that the distant future could unleash. Now, even though the context of this judgment was a little different, but here we may very well say that the flexibility being spoken about also applies to the justice delivery system, especially in times of COVID. Now, after the lockdown started, lockdown measures were imposed. Our High Court started hearings, commenced hearings, and only extremely urgent matters through video conferencing. Now, who would have thought that justice would find its abode in the internet and that video conferencing applications would host courtrooms which are, so to speak, spread across the judge's chamber and the advocate's chambers? Now, be that as it may, the upshot of the COVID outbreak is that justice has gained a new set of indispensable requirements. Now, as Mr. Mitra had observed in his introductory speech, primarily it is the internet. Now, it has almost become the situation is such that a robust net connectivity has become the sine qua non for the judiciary now. Now, the lawyer and the judge alike must possess a good connection if a lawyer is to argue his case effectively before the court. And this has not been without its raging controversies. There have been widespread complaints and hearings that hearings are disrupted, the link fails, the connection drops, or sometimes the lawyers cannot even enter the virtual courtrooms to argue their cases. There have been widespread complaints in this regard, and not this alone, but there's a wider problem also that I, at least being a junior member of the bar, have seen, and that is one of inequality. Many lawyers in our courts, they do not come from uh, equal financial backgrounds. Some do not come from very well-to-do backgrounds, and for them, and they stay in certain places in the state, maybe outside the city, where internet connectivity is not very robust. And therefore, the complaint is that while only a small section of the lawyers can access the courts, can take on clients, argue their cases, and earn a living, the others cannot. Because you see, for lawyers are not only means of securing justice, they also have their own livelihoods to preserve. Many lawyers cannot even travel to the court because of lack of transport options. There's a reduction in work, and accompanying reduction in work, you have various mental health issues. We have seen very unfortunate incidents of suicide and other issues like depression, etc., among lawyers. And these have tried to be, the courts have tried to address this in our state. And recently we have hybrid hearings which have started, which also has its own set of difficulties, as in where one party is physically appearing in court and the other party, the other lawyer for the other side is appearing through VC, and he does not have enough access or his connectivity is not that great, whereas the lawyer, the counsel for another party has full access and the privilege of being able to argue in person. Now, having said that, the courts have really not taken up all matters during this period. Matters are being restricted to very urgent matters, which again is a problem for a large number of litigants because everyone cannot approach the court. And just as from the perspective of a court, a matter is not considered urgent, but for every single litigant who is suffering, say, an eviction or any other problem, be whatever it may be, for him, his problem is the most urgent problem and the most pressing issue in the world. So he cannot have his grievances addressed by the courts. Now, this situation is at least better in the High Court where we have virtual connectivity. As far as the lower courts are concerned, there is no virtual court infrastructure which exists. I've been told that Consumer Forum has been sitting 2 days a week. Only criminal matters are being taken up, and that too in a restricted manner. Civil courts are virtually non-functional. The filings were closed in the subordinate courts. They've recently started, but matters are being filed but not being able to be taken up by the courts. Therefore, matters are piling. But nevertheless, not to be too pessimistic, there are efforts underway where lawyers have also been uh, placing requests, or in some cases, resorting to agitation to ensure that physical courts resume. Now, as Mr. Mitra said, that it is not possible to replace physical hearing lock, stock, and barrel with virtual hearing. Virtual hearing is only a mitigating tool in times of COVID. Now, we tend to have extreme views. Either someone is extremely satisfied, either someone is extremely dissatisfied with the present state of affairs. Now, in my humble view, neither is helpful, because reactions in these times must be measured and pragmatic. There is a problem of access to justice in the face of crippling infrastructural problems, but we must be looking at immediate mitigation of problems to the extent practicable, because one must be very realistic. At the same time, we must not be very satisfied with the state of affairs, but also look for ways to improve the system constantly. So let us come to solutions. The first thing which I must draw everyone's attention to is that the state must release adequate funds so that the virtual conferencing infrastructure is made robust, so that all courts can sit, not just the High Court, but these infrastructure can be put in place in the subordinate courts, where if the judges cannot sit in the courtrooms, there must be at least some place within the court precincts where a lawyer can come and sit in front of a computer and argue. And this must not be restricted to only urgent matters. The state must realize that effective functioning of the judiciary must be among its topmost priorities. Granted, in the face of an unprecedented economic lockdown, funds are hard to come by. But I believe that when there is a will, there must always be a way. We must have physical hearings as well, gradually, in a phased manner. Now, thanks to the World Health Organization, we have state agencies in India, we have foreign organizations like the CDC in the US. There are plethora of guidelines which have come out throughout the world, which we can follow and can ensure that physical functioning of courts can resume with appropriate security measures and safety protocols. It is something which is not unheard, because, as we know, in a large part of the state now, the phase of unlocking of society in general has started. Many offices have reopened. Now, there must be a difference with courts, obviously, because court is a public place where there's a gathering of a large people. Now, that can be restricted. A limited number of lawyers can visit the courts. Only the arguing counsel with a junior, maybe with the advocate on record, one representative from the client each, who may be permitted entry only when the matter is taken up. Yes, there will be problems, but we cannot look at perfection all the time, especially in these times. There must be a pragmatic approach. Now, another thing is improving connectivity is, of course, I would limit to that extent, notwithstanding the views of my revered senior, say that in the long term, the world is becoming a global village, and therefore internet connectivity, whether there's physical functioning or not, is a must, because that is the way to the future. For that also, and we must take steps to improve VC connectivity. And I'm sure we all have these infrastructure in place in our homes. This is not something which is insurmountable. This can be put in place in a relatively short period of time thanks to technology. And that is also something we must be looking at, because that will greatly ease the problem of access to justice. The problem of, in some cases, litigants cannot come to the court physically to converse with their lawyers. In certain cases, lawyers cannot come. So for them, at least, the VC mechanism must be in place, because we know VC hearings have been taking place in certain kinds of matters even before the COVID outbreak. Now, finally, I would like to say that this is not a problem of the state alone. All stakeholders must come forward and lend a helping hand. I know, for instance, there are civil society organizations like the one which I have the privilege of being associated with, the Commonwealth Human Rights Initiative. We have been carrying out studies and surveys to help the states cope up better with the COVID outbreak. For instance, we have prepared an external checklist for judicial officers, which will help us assess where we stand and thereafter look for means and ways to give suggestions and, if necessary, actively help out state agencies and the judiciary in improving the systems, be it in resumption of physical hearings or upgradation of VC facilities. So again, I repeat that we must look at mitigation right now. A perfect solution is not possible. Now, judicial reforms are always urgent, but due to these problems, they have proceeded at a leisurely pace so far. What the pandemic has done is that it has made what was necessary very necessary and what was urgent very urgent. Now, a functioning judiciary in our state, as for the entire nation, is in the interest of not only the common man on the streets, but serves to the benefit of the state itself. Because ultimately, the preservation of rule of law can only make governance easier. And therefore, we must keep in mind one principle, that is, use adversity to your advantage. We have an adversity, we must make the best out of it and upgrade ourselves to be in step with the times. And for each stakeholder, the pledge we must take for each one of us, in the words of Robert Frost, but I have promises to keep, and miles to go before I sleep, and miles to go before I sleep. Thank you.
Thank you very much. Deepan, you have made a number of very, very valid points. But what I like about your speech is that it is full of positive thinking. You are an optimist. I'm very glad about that. And your speech was full of uh, thinking for the future, and that is a great thing. Uh, what Mr. Sarkar has spoken to you basically is a very fundamental issue. He said that it is the interest of the common man for which our constitution has been framed and for which the judicial system functions. You see, the thing is, he's absolutely right. You see, the final cause of law is the welfare of society. Ultimately, that is the aim of any profession, any avocation. The final cause is the welfare of the society. Uh, Mr. Sarkar quoted T.S. Eliot. If I may quote Benjamin Cardozo, he said that the rule that misses its aim cannot permanently justify its existence. I'm repeating it. The rule that misses its aim cannot permanently justify its existence. Therefore, the aim of social welfare must be the predominant factor in shaping the judicial procedure and therefore must ultimately guide our conduct and activities in the matter of dispensation of justice. And this is the main theme of Mr. Sarkar, and I'm very glad that he has made this point. He has also made this point that because of the poor infrastructure, uh, this technological communication, which we are gradually adopting in the Supreme Court as also in the High Court, have not permeated to the district courts and the subordinate courts. He's very right. But then again, as he rightly points out, what was a necessity has become an urgent necessity. Therefore, you see, necessity is the mother of invention. Today, you see, when I started my practice, I am just giving my example. I didn't have a library. As I went on in course of years, I gradually, bit by bit, you started collecting books. And today my library is a full-fledged library. Similarly, when we find this problem that very many of us do not have the wherewithals for the purpose of setting up an infrastructure of having virtual hearing. We don't have computers. We don't have the linkage. Now, in a situation like this, we should not sort of, so to say, throw in the towel and say, sorry, we are helpless because I don't have the money. Remember that when a lawyer started his practice or starts his practice, he doesn't have a library. But in course of time, he bit by bit, he gathers and he builds stuff. Today, books are an essential tool for a lawyer in his profession. In course of time, I say within 5 years or so, a computer, a laptop, a desktop computer, the linkage, the communication services, the technological feats, all these will become an essential tool of a professional lawyer. So I agree with Mr. Sarkar that, and he rightly points out that even though there are so many ifs and buts, so many difficulties in our way, but ultimately we'll have to overcome them and we will have to meet the future with, with optimism. We cannot just, so to say, throw in the towel and sit tight and say, sorry, we can't do it. We will have to meet the future. And therefore, my request to my junior friends is this, that even though you do not have the system intact today, but time will come when we'll find that this will become a part of your life, and you will not be facing the difficulties which you are facing today. Thank you very much, Mr. Sarkar. We are very much, I should say, we have become very much wiser from your discourse.
Okay,
Now,
sir. So, before we
Thank you.
proceed to the next
yes,
distinguished speakers, I would like to draw the attention that, Advocate Jas Uppal has joined us from Britain. She's a very eminent advocate. Thank you, madam, for being with us this evening. It's a privilege to have you, and we would also like to hear something from you, after all the presentations. So, I think, thank you for being with us, madam. And I would like to request the moderator, please, sir, proceed. The floor is all yours. Thank you.
no, no, before I proceed any further, I must personally, on my own behalf and on behalf of Institute of Social and Cultural Studies, welcome Advocate Jas Uppal to this
Thank you.
particular discourse.
Thank you very much. I'm sorry I didn't have my mic on earlier. So I'm grateful to Miss Roy and to his good self, sir, for inviting me. It's my pleasure. It's very nice to listen to comparative systems. We also have the same problems, but not to that extent, as far as Wi-Fi is concerned. I'd love to learn more, and I certainly will, for what it's worth, forward my observations. And hopefully we can all do something towards getting the system fixed.
Thank you very much.
Thank
Thanks
you.
a lot. Now, uh, I will invite now our third speaker, Sri Orindam Mitro, advocate, who is the additional government leader senior panel in Siliguri, and ex-chairman of Siliguri Municipal Corporation, and honorary lecturer, Indian Institute of Legal Studies. Mr. Mitro is wearing many hats, and therefore I am sure that his experience will really make us wiser after today's discourse. Mr. Mitro.
Thank you so much, sir. Actually, good evening to all of you. Honorable Mr. Moderator, sir, my most respected speakers and respected participants. Mr. Sarkar, in fact, the speaker just before me has covered aptly the entire scenario emerging now. I thank the Institute of Social and Cultural Studies for organizing the webinar and feel honored to be invited to speak. In view of the wider subject of discussion today, sir, I would like to address it from a lawyer's perspective principally, the scene in North Bengal. The North Bengal region covers 8 districts of the state of West Bengal. There are 17 bar associations in the region with around 4,000 odd lawyers practicing in the courts here, along with several lawyers practicing in the taxation matters. Now, firstly, sir, I wish to begin with a very interesting comment that I have come across recently. During the Second World War, when the German Air Force was bombing London, The British Prime Minister was taking stock of the casualties and economic devastation and asked, uh, Mr. Churchill asked, are the courts functioning? He was informed that the judges were dispensing justice as normal. And he replied, thank God, if the courts are working, nothing can go wrong. Now, taking the cue from that, I don't know whether it will be right to say that everything seems to have gone wrong with the courts not functioning normally now. In fact, the courts ceased functioning from the 16th of March after the initial notification of our Honorable High Court, which was supported by the West Bengal Bar Council. The functioning of the courts came to a standstill, and it continued throughout the nationwide lockdown and even thereafter. Only limited functioning of the district and session judges and additional district and session judges on a roster basis was available for bail matters apart from regular forwarding of arrested persons. There is a vital piece of information, sir, put forth by the National Judicial Data Grid. In April this year, a meager 82,725 cases were filed in Indian courts, as against an average monthly filing of 14 lakh cases in 2019. And only 35,169 cases have been disposed of in April this year, sir, as against 13.25 lakh cases disposed of on average every month in 2019, sir. North Bengal has been no exception to this dismal national scenario, sir. The circuit bench of the Honorable High Court at Jalpaiguri stopped functioning until online resumption on a limited basis from the 17th of June 2020. So it remained closed for a rather long time, sir. Bail applications in the lower courts were being filed both physically and online. Online facility, of course, was not available in all places. Since June, sir, physical filing of cases, both civil and criminal, have resumed in most of the courts in the region. Physical filing, sir. Only ad interim injunction prayers were heard, but mostly through WhatsApp hearings. Consumer courts have started functioning, but with limited staff, limited resources since the later half of May, sir. The DRT bench has been entertaining online filings, and virtual hearings have been taken place in urgent cases only. Now, a lot of lawyers and clients, they have not been able to access the courts. However, courts have so far not passed any adverse orders in their absence, and that's a relief for the lawyers and the clients also, sir. Now, it cannot be denied that the sense of fear has loomed large, sir. Efforts have been made to follow up physical distancing and other norms and protocol, but there is always the fear as to what will happen if normal functioning is resumed. Now, I have perceived, sir, I have perceived a sense of impatience building up among the lawyers. The condition of a major section of the lawyers is indeed pathetic. We have to admit it, sir. They have been practically without any income since mid-March. This surmounting frustration is more so, sir, because it is perceived that normal activities have resumed in most spheres except courts and educational institutions, sir. In this backdrop, the various district judiciaries are now beefing up measures to initiate regular physical functioning of courts in a limited manner, along with hearing through video conferencing. Such efforts have been welcomed in some places like Siliguri, where normal functioning is expected to resume from 1st of September, sir, with both physical hearings and video conferencing to be followed. But some bar associations like Darjeeling, sir, they have preferred to function only on alternate days, and they have in fact, laid down certain conditions which they say will be very important in the scenario, and which they wish that to be followed, like evidence to be taken only in limited number of cases, hearings to be fixed for only limited number of cases, arguments to be addressed only in limited number of cases, both in civil sides and the criminal sides, sir. Now, so far as the online process is concerned, sir, it has emerged that a major section of the lawyers in the lower courts are finding it difficult to adapt to the system, sir. But this situation offers an opportunity also, sir, to create the next generation justice platform and motivate the lawyers to learn the skills to navigate the digital system. So it's very important. Now, as your respected self has commented, sir, necessity is the mother of invention. Now, a considerable number of lawyers across North Bengal have participated in the webinar on e-court services held on the 25th July, organized by the E-Committee of the Honorable Supreme Court. which was certainly an illuminating session, sir. Most lawyers have also submitted the details called for by the Bar Council of India as required by the E Committee of the Supreme Court. Now, this is also a step in furtherance of that objective, sir. Now, this is a new era, sir. We have to get ourselves accustomed to the new environment. Now, so far as the sufferings of the lawyers are concerned, sir, those in need have applied to the West Bengal Bar Council for that one-time financial aid, and many have already received the aid, but that is not the solution, sir. We want to return to the courtrooms, and lawyers are comfortable arguing matters in the courtroom, sir. You will definitely agree to that. That provides the environment, that provides, the extra the energy that we get, and that we do not get by sitting down in our chambers while arguing. So there must be a blend of this physical hearing and the online process that is being evolving, sir. And we have to see how we can resume, the normal functioning of the courts. Of course, not ignoring the fact that the digital process has to be maintained. Now, another feature, sir, which I have perceived, I think, as a lower court advocate, I can aptly say, sir, this is noteworthy. A lot of litigants, in the face of this pandemic situation, uncertainty about the opening of the courts, they are tending to opt for settlements of their disputes outside court. Now, I do not know whether that's a ray of hope, but that definitely is a new way of looking at things. And I would like, again, sir, on a positive note, to end with the words of Albert Camus, the Nobel Prize winning philosopher, sir. He said, "In the depth of winter, I finally learned that there was in me an invincible summer, sir." In this period, the lawyers have been sharing a lot of thoughts, ideas, legal knowledge through the social media. We are doing that now, right now, sir, while gradually gearing up for the new norms of judicial functioning, and eventually we are radiating the dawn of the invincible summer in us, sir. Thank you, sir, for rendering me a patient hearing.
Thank you very much indeed. Thanks a lot, Mr. Mitra. It was extremely illuminating and a speech which was radiating with hope. And this is what I liked about your speech. Your last comment that by reason of this COVID, the tendency of the lawyers to settle matters out of court,
Yes,
it is a very good sign. I mean, you see, every, I should say, disaster has got some, what should I say, a silver lining. Every cloud,
yes,
dark cloud, has a silver lining. This particular situation, which has developed in our country, this is one of the good things that has been brought out. If people can settle up their matters, forced to settle up their matters, if otherwise perhaps wouldn't have been settled, and it would have gone on to protracted litigations for years to come, I think that is a good sign. Now, we have received plenty of information from Mr. Mitro regarding the goings on in the subordinate court and subordinate judiciary. I again say that in so far as we are concerned, we are having a lot of handicaps, particularly the lawyers coming from the districts, lawyers who are not in the main city or town. They are having a lot of problems in the matter of uh, this technological development and virtual hearing. A lot of problems is there. But this particular problem will have to be solved. It can't be solved overnight. I agree with you. It will take some time. But so long as we have the hope of having this problem sorted out in course of time, I say that our future is not dark. We have got hope for the future. Um, I also agree with him, and this is a bit of a revelation for me, that district courts are deciding now to function physically. It's a good thing, but then again, I am thinking of myself. At my age, if I go to appear in the courts physically, I expose myself to the risk because I don't have much, long way to go. I can see the light at the end of the tunnel. But then again, then again, who wants to go away leaving this beautiful earth of ours,
Yes.
leaving our beautiful company, leaving beautiful people? Who wants to go away? So, insofar as we people are concerned, the, those who have crossed certain age, they will have to be careful. I fully agree with you that ultimately the physical courts will have to start. And as I said, that virtual court is no substitute for physical court. You do not get 50% of what you get in a physical court when you are doing matters by virtual court. But nonetheless, I say that I think it will be quite some time in future that we will have to go continue with the physical court and virtual court together. And ultimately, the problems will be sorted out. When the problems are sorted out, we may come back to the physical court wholly, or by reason of the fact that in the meantime, the virtual court will develop to such an extent that maybe virtual court will be competing with physical court. Maybe in one of those, in some time in future, perhaps I won't be able to see it. You people will be able to see the virtual court and physical court working together, as it is in Singapore.
Right.
Thank you very much, Mr. Mitchell. It's very
Thank you, sir.
illuminating, and we have learned a lot. Now we go to the last and the fourth speaker, a young advocate, Mr. Shaikh Chakraborty, who I know very well. And how I know very well is that he came and joined my chamber. So I have got some soft corner for him. Now I call upon Mr. Chakraborty to make his discourse. He will say.
Indeed, sir, it is a great honor for me that I got this opportunity to speak at this webinar, especially since the senior with whom I started my professional career with, Thomas sir, is also a part of this panel, and my chamber senior, Joyanta sir, is also there in this webinar. It's a great honor for me, definitely, to speak in this occasion. With regard to COVID-19 and the effect of it on the courts, the main issue I see here is that court did not take e-courts and e-systems very seriously till this pandemic happened. It has been in the works for a very long time. For a long time, the courts have encouraged e-filing, have framed guidelines for e-filing and e-court mechanisms, but it was moving at a snail's pace. What was moving at a snail's pace has, in fact, had been speeded up by the effect of this pandemic. And as a result, what we are seeing today is that although we were unprepared for this magnitude of problem, we have had to adapt very quickly. And the fact that even adaptation in such a limited way has been possible to do so is a encouraging sign in itself. The fact that the courts have been able to carry out virtual hearings with literally zero preparation beforehand is a very encouraging sign. It shows that if the court is so inclined, if the lawyers are so inclined, if the system is so inclined, we can indeed move ahead in the virtual world. We can in fact increase our adaptation of technology, and we can in fact proceed as per exigencies as and when they arise. Now, the main complaint I found is of connectivity. Now, there is a simple fix to connectivity issues, at least on the part of the High Court itself, is to invest more in the infrastructure required to hold hold virtual hearings in the High Court itself. There is a need to upgrade the infrastructure in order to ensure that more virtual courtrooms can be held. Today, as up till August, it was the proposal of the High Court was that 5 single judge benches would sit, and I think 3 division benches would sit. Now, there is no reason why every bench cannot hold virtual hearings at this time. It is merely the lack of infrastructure which is preventing such a hearing from taking place, because all the judges are not equipped to have hold virtual hearings, and perhaps the High Court itself is not equipped to handle virtual hearings of such magnitude. That is the urgent requirement as per me. As per me, one of the most urgent requirements at the current time is to ensure that more benches can sit both virtually and physically, and that more matters can be taken up. Because the main problem that we've been finding is that only urgent matters are being taken up. Now, the fact is, only the definition of urgency is so subjective that there are bound to be a lot of people who remain aggrieved by what they consider to be urgent matters not being taken up by the court. The fact remains that for what is considered urgent by you may not be considered urgent by me. And similar for a third person. A third person may not consider either of our matters urgent. The very subjective nature of the term urgent is what is causing a lot of lawyers to be aggrieved that their matters are not being heard despite the urgency, perceived urgency of their matter. Now, the only solution for that is to ensure that more matters are taken up through virtual hearing and more judges sit in the virtual benches to undertake such hearings. Now, of course, as Joyanta sir very rightly pointed out, sir said that virtual hearings can never replace. I can recognize that my sir's ringtone. Heard it several times in
I'm
previous.
sorry, I beg your pardon, please.
No problem, sir. Of course. No, but that's the thing. The thing is that we need to, of course, I agree with sir definitely when he says that virtual hearing can never replace physical hearing. It cannot. It definitely cannot. Because in physical hearing, the kind of the lengths to which you can go and the ability for you to argue at length is far greater, because there is no problem of connectivity, there is no restriction on the number of counsels who can join, and there is no restriction on how lengthy your hearing can be, because at the end of the day, in a virtual setup, there is these restrictions that have to be placed because of the limitations of the infrastructure. Here, I also feel that one of the problems that has been faced by the Calcutta High Court in particular has been the choice of platform that has been used for virtual hearings. I am not a huge fan of the software Microsoft Teams, which has been used by the High Court so far in having these virtual hearings. But I'm sure that there is some good reason as to why it has been the preferred software of the High Court in having hearings. But personally, it is not the first of all the most user-friendly software, and it's not the most reliable software to use. So that is one of the shortcomings I found in the virtual hearings that have been taking place at the High Court. Now, of course, we have to work with it. We have to work with it. We have to make sure that we make do with what we have. And I feel that one of the ways that can be done is by having a better understanding of the softwares available, and to have a very considered look at the platform that is to be used for virtual hearings. That is one of the main things that we to do. Taking a point from what Mr. Anindam Mitra was saying, very rightly, right today litigants are preferring alternative dispute resolution modalities to avoid having to go to courts. Now, that is another thing again. Prior to the pandemic, the courts have always said that mediation should be encouraged, mediation should be given a push. But at the end of the day, what we found in practice was that although the court did state this on several occasions, very little had been done to actually evolve mediation as a dispute settlement procedure. I mean, if you look at it, although I have personally received training as a mediator, I can say almost assuredly that mediation training itself is scarce to non-existent in our country because it's simply not been taken seriously enough. Now in the pandemic situation, now with the courts taking up restricted matters, mediation is being seen as an attractive option, but there's not enough people providing such services to in order to make it an attractive prospect. The thing is that ADR should have always been something which was taken very seriously. Unfortunately speaking, it has not been taken very seriously either by the bar or by the bench or by the litigants themselves prior to this pandemic situation. And thus, it is only when push came to shove in terms of the courts taking up limited number of matters that ADR has been seen given such importance. It was supposed to have always been given a high degree of importance and should have been something which was encouraged by not just litigants but by lawyers themselves. Lawyers, when dealing with clients, ought to have given priority to trying and resolve a conflict prior to it coming to court. Unfortunately, it is the bar has, I would, in my humble opinion, say the bar had abdicated part of its duty to try and resolve matters prior to it coming to courts because many lawyers did not take up an ADR friendly approach, mainly because perhaps they weren't aware of this mechanism or weren't trusting enough of the mechanism to actually take that approach. In future, what I would say is that there must be a intermixing of the virtual and physical platforms of hearing, because one of the main complaints that any lawyer from outside Delhi always has is that there is only one Supreme Court in our country. The access to the highest court of the land is primarily given to those who stay close to Delhi, in the vicinity of Delhi, because it's easier for them to approach to the Supreme Court. Now, if you are not going to establish more benches of the Supreme Court, which is ideally the solution which ought to have been implemented long time ago, the next best thing you can do is ensure easier access of citizens to the Supreme Court by having virtual hearings of the Supreme Court, where Supreme Court judges would devote at least part of their time in taking up virtual matters, where lawyers and litigants from different parts of the country can appear before the Supreme Court and make submissions, thus increasing the accessibility of justice in the highest court of the land to citizens across the country. Another thing that is, I think, will come rather much sooner than my learned senior would think, is intermingling of virtual and physical courtrooms, because I feel that this pandemic has been a learning situation for the judges and for the lawyers in how a virtual court may function, and in future they may be less apprehensive about matters moving on a virtual platform and may be more accustomed to the idea that a court may hear one party in person and the other party virtually, or perhaps both parties virtually. I think what has really changed with the pandemic is the mindset of a lot of people have changed and they have adopted technology. I can only speak to my own senior, Joyanta sir, who has most remarkably adapted to the modern technology. And while he was very hesitant initially in approaching his laptop and his mobile phone, he had my learned senior shown very bright example of himself by adapting to modern web conference, video conferencing platforms, and has taken to it almost like a duck to water, although it would have seemed impossible for him to think of such a thing prior to the pandemic coming around. And the thing is the mindset of the seniors as well as the juniors has changed. They have become more readily responsive to technology owing to this scenario, and I think in future we may find it much easier to bring about the e-courts because of a lack of hesitation on the part of both the bar and the bench to make things more technological and to adapt a more tech process and system. With that, I'd like to end my speech. Thank you.
Thank you, sir. Thank you very much indeed. Uh, you have, first of all, I thank you for saying that pandemic has at least improved me. I have, I have become an improved man, according to you. Yes, you are quite right. I used to have many apprehension regarding the user of electronic gadgets. You had been the person who had been responsible for initiating me into, uh, the electronic world. And by, I have learned a lot. No, but you are quite right that connectivity is one of the most important factors which had been, uh, to a large extent, uh, disturbing the functioning of the court through virtual media. You see, I feel that there are four factors which are very necessary for proper functioning of court through virtual mode. And in another webinar, I have mentioned this. First is adequate connectivity, as you rightly point out. Number two is good and efficient software, which you have also pointed out. Third is trained set of administrators. This is very important. Trained set of administrators, if you don't have, then you will have problems every now and then. And so fourthly, this is really an offshoot of the third one, improving the knowledge and educate all participants in the process, namely lawyers like me, honorable judges, and the court officers. Until you get all these four working properly, four factors working properly, I do not think that you can have a very smooth functioning of virtual court. You are quite right in saying that insofar as we in Calcutta is concerned, we had been abdicating our duty to settle disputes before coming to court earlier. Now, today, we are forced by reason of circumstances to tell the clients that, look, the position is such that in a situation, in the COVID situation, your matter will take a long time to come up on the list. So, in the meantime, if there is any possibility of settling the matter outside the court, do sit together and settle. And in fact, I personally do not feel, excepting for very few matters which can't be settled, if both parties be reasonable. So, situation is such. This is one of the good things of COVID which has come out. I do not know to what extent you will say this is a good thing, which is the result of COVID. That now the possibility of settlement outside the court has been increased, as you rightly point out. Now, I must say that it has been a very, what should I say, learning experience for me to hear all the very learned speakers. Each one of them has thrown light on the subject, had spoken various aspects, including problems and the solutions in respect of this pandemic, which is the pandemic which has created these problems. And also we have come to learn a lot of remedies which can be thought of for the purpose of proper resolution of disputes. Because one has to remember that resolution of disputes is one of the most fundamental uh, tenets of a civilized society. A civilized society is, or rather I should say, a society can be said to be civilized only if it has got a civilized way of settling problems, settling disputes. And today, in today's discourse by different speakers, we have come to learn that there is a possibility, in spite of COVID, in spite of the fact that the courts were closed for a long time, there is a possibility that in future our virtual courts will become will assume more importance And ultimately, perhaps, this will become one of the major ways of settling problems. Thank you very much indeed to all the speakers for their very wise and very knowledgeable discourse. Now, I think I shall invite uh, our very revered advocate, Jasupal, to say a few words. You have heard our boys speaking. Now, I would like you to give your impression from what you have heard today.
I'm grateful. Thank you very much once again for the invitation, Mr. Mishra, and everyone else involved. I'm very interested in this subject matter with regards to the visual hearings, the virtual hearings, should I say. That is a matter and a problem faced by loads of people around the world, loads of countries, loads of legal professions around the world. So it's not unique to India. So you mustn't feel it's something that you're left behind in. What you may have experienced, and I think it's already been said, is that you weren't prepared for it. And it requires a lot of thinking and planning ahead. So, but don't let that leave you out, because your country is supposed to be the center of IT. So I don't think it's insurmountable. It needs to be done, and it needs to be done quite efficiently. You also have a gap of people who do not have access to justice. One thing I haven't yet heard mentioned is the right to and the access to justice is a human right. It's not something something out there, something in a theory. It's an actual right. So people who are not getting access to justice are being denied their human rights, whether it's because of the lockdown or because they haven't got actual access to justice, interpretation, if they're poor. All those are elements which prevent them from exercising their human rights. So access to justice is in the UN's Universal Declaration of Human Rights. So it's necessary. I think people need to be made aware of that. It's not just the financial side, or the lawyers not making money. That is obviously a problem. That's an issue. It's a result of the COVID. But before all that, access to justice is a human right. So there should be more ways of allowing people, enabling people to access justice. For example, India was maybe not one of the first, but they did start allowing people making claims online, filing information online in readiness for a hearing. So we need to look at that, how you can get people to fill in their applications online. It's simple as that. They're making a claim, or if they've got a grievance. If they haven't got access to the internet, if they haven't got a good Wi-Fi system, they're going to once again be denied that right, and therefore that right, that human right to access justice. So that all those things need to be looked at as well, and it's a learning curve for everyone. Even in this country, I've just this morning, hence the reason I was late, did a hearing online. It wasn't visual. It was a telephone directions hearing, which was listed. I think we did well in getting that, but obviously it's not the same. I understand the restrictions, but I think importantly at this stage, you need to get the infrastructure ready, and you need to have people who can help people to make their claims online, or they register their grievances. I mean, one of the things that I don't believe India has got, we have here in the UK, are citizen advice bureaus. They're government run or government funded, they're government funded, and they are ways of enabling people to access justice. So they can, so anyone can walk in, can make an appointment, if you like, it used to be that you can walk in. I think with things changing, especially with COVID, you can make appointments and then you can go through whatever your grievance is. And if it requires legal input, then you can have there will usually be a lawyer present, a solicitor or they might arrange for you to meet a lawyer so that they can help you with your claim and they can fill in the forms. And I think also with the younger people, the younger generation, they are IT literate, and maybe they should be encouraged to help go out into the communities. If you're a trainee lawyer, I don't know whether you have that expression, or if you're a legal clerk. I am aware in India they have a lot of legal clerks. My understanding is that they've got a lot of experience, they're not fully qualified to call themselves lawyers. But again, those people can help those who are not IT literate or even literate to get their claims across, to the courts. Now, I am also aware of, before the COVID lockdown, that there are many cases outstanding before the courts that haven't been disposed of. There seems to be a very, it takes a long time to get a case into court and get it disposed of. And I'm aware figures such as 35 to 45 million cases are outstanding. So I think going back to the virtual hearings, maybe I wish they could have started earlier. But if it means COVID has been the trigger to do this, then that needs to be addressed. So it's not just about COVID and the bad infrastructure for IT. I think you need to look at those as well. The Indian judicial system, about the backlog as well. This virtual hearings is a good way of dealing with those as well. So because I wasn't prepared for this, I've covered several aspects, but there's the Wi-Fi, the backlog, the literacy, the IT literacy, and also reading in the media. I look at comparative systems out of interest. So I think you're missing something there by using the legal profession, the younger people in the legal profession, to help others, whether it's on a pro bono basis, a voluntary basis. It's something they can put down in their CVs, improve their chances of getting a job, to relate to people, have empathy. It's not just about the financial side of things. You also need, which I was trying to think on and nearly forgot, is appointment of more judges. I'm absolutely horrified to learn the lack of number of judges that you've got. So how do you expect cases to be looked at? Again, that's another nail in the coffin of human rights, because if you are denied access to justice because there's not a judge available or a court nearby available, what's the point? That is a gross abuse of human rights. So I think that needs to be looked at. The recruitment of judges, sort of independent, impartial recruitment of judges, that's imperative. And also, I don't know whether, maybe I'm going off a tangent here, but I think it's all relevant because it's all about access to justice, is how much of human rights are taught in the legal profession, in the universities, and with the authorities, the civil service, the police authorities, all who are part of the legal process, the enforcement of criminal justice and justice generally, how much they are aware of. They're all in the mix, and they're international. You need to be aware of that. And I think I was going to say thanks to COVID. I don't mean that, but I mean that needs to be addressed. This is a right time to address all these outstanding aspects, such as the appointment of judges, even in the rural areas, which India composes of large rural areas. They don't even get a look in, least with the cities and towns, you're talking about virtual hearings. They don't get a look in. Again, it's to do with literacy, including IT literacy, and being in a position to, access justice. I'm sorry it's a bit all over the place, but as I say, I wasn't prepared for it. But those are the things that have always concerned me. And I think you also need to look at other systems. For example, your system is based on the English system, English common law system. You need to compare. You shouldn't be, my observation, I'm not being disrespectful, because in this country we're taught to say what we feel, whether nobody likes it or not. We don't sugarcoat it. We shoot from the hip, as the Americans would say. But so we need to look at, you need to look at, should I say, at how other systems work, learn off them. There should be more interaction. There should be education for lawyers, ongoing education. Sorry, there was something happened. There was a blip there. Ongoing education for lawyers. We have a system where we have to keep a record of all our training, our learning, which our regulatory body, which is the Solicitors Regulatory Authority, can check what we learn, what we're doing, whether we're up to date with our learning. I think there's a potential for so much to put in place in India as well, so that we can all benefit. In the past, India has thought of itself as separate from the world, politically, maybe loads of other issues, etc. But I think in this day and age, as you've done with the IT, get yourselves out there, interact, join in forums internationally. Don't work alone, because no man's an island. No man or woman's an island. You need to learn off other people. You've got to recognize that you learn off other people. You just don't acquire knowledge by osmosis. It's practice, learning from other people, other systems, and come out with the best one, as you've already proven in terms of IT. Are there any questions?
We are very grateful to you for your discourse, but I can tell you one thing, that insofar as India is concerned, though Indian legal system is based upon the English law primarily, but over the last 70 years, Indian, I should say, the outlook has expanded. And now, if you look into the Indian law, I am not talking of the contract law, which is based upon the English law, or I am not talking of the tort law. But when you look into the constitutional law, it is much wider. The relief granted under the Constitution of India is much more than whatever relief the English courts give or the American courts give. The Constitution of India, by reason of interpretation over the years, has expanded its ambit, so much so that to a large extent, the concept of public interest litigation, the concept of the protection of basic human rights, these concepts are coming. So people have become much more conscious about the right to education, the right to decent living, right to house and residence, etc. These concepts were not there when India obtained its independence. But over the years, the horizon has expanded, and so much so that now I think the constitutional law in India gives much more. So, for example, judicial review. Judicial review principle in India is much wider than what is in England or what is in America.
No,
so
I'm so sorry to interrupt. Please don't take it that I was criticizing. I get a lot of Indian people contacting me because they're in trouble abroad or even in India. and I base my submissions and experience of dealing with these people. For example, I've had not just one but several cases where they've tried to report something to the police, and the police has just shooed them out of the police station. They don't want to help. So a local lawyer, as a local lawyer wouldn't go with them to lodge the report because nobody's interested. From my experience, this is, and they would, so they end up not reporting the matter and not receiving the justice that they are entitled to. I've also referred to the Indian Constitution on a number of cases that I've dealt with, which involve Indian nationals, to say, for example, I think it's section 33 that you have, India protects its nationals, and that's something that, for example, the embassy staff are not aware of. I've got no criticism about that, but I'm saying look even wider, such as the international law on human rights, the international UN Declaration of Human Rights as well, because you'll find they cross over with the Indian Constitution anyway. So it gives you even more wider powers.
Right.
Thank you for letting me clarify that.
Thank you very much indeed. Now we may come back to our subject for this evening's discussion. Now I would ask if there is any member of the audience wants to ask any question of the speakers who had deliberated before you. Any question?
Yes, I have a question.
Who are you? Give the name.
My name is Arundhati Ray.
Yes.
And I want to thank Ma'am Upal for highlighting something extremely important, like human rights. And you hit the nail on the head, I thought, in every word that you said. So thank you very much. That legal rights are not, just to do with lawyers and clients, but they're very much human rights. Ma'am, it was a pleasure listening to you. Thank you so much.
Thank you.
Very well. Next, anybody else? Any question?
10 minutes more to discuss, sir, and then we shall go towards, wrapping up the session. So please, ma'am, I request you to keep it short, and so that, everybody else can be addressed. Thank you.
Thank you so much. My name is Noyuni Basu, and I'd like to ask any of the members who would want to respond to my question, which is, in this scenario of COVID and lockdown and post-lockdown, the gradual unlocking process, what is the situation of domestic violence cases, of domestic abuse cases, especially emotional abuse, mental injury? Are these cases, being heard in the courts? How are they being heard? How are they being addressed? That's what I'd really like to know.
I would like Mr. Dipon Sharkar to answer this question, and then I shall ask Mr. Orindam Mitra also to react to this. First, Dipon.
Ma'am, thank you for the question. Thank you, sir, for referring the question. What I have seen, since I primarily practice before the High Court, I have seen certain urgent matters being taken up with respect to domestic violence, etc. And by and large, I think none of the substantive problems have been addressed. As it is, it's very difficult to get your matters listed, as Sir had pointed out earlier. Only a few matters are getting listed, few and far between. And even if they are, all that the courts are looking at right now are to come up with stopgap solutions. For instance, where there's a domestic violence or a divorce case pending, then the courts are concerned with, for instance, one spouse coming in saying that he wants to. In fact, I was watching such a matter being taken up today while I was waiting for mine to get taken up, where all that they wanted was for the father to be able to see the child virtually. So, only stopgap solutions to that extent are being taken up. As far as the lower courts are concerned, I hear that the criminal courts are functional, but then again, the functioning is impaired. So I would assume that not many matters are being addressed by the courts, and they cannot. I mean, the situation is really terrible, so to speak. Whatever is possible, as I said, to mitigate the problem, the courts are trying to come up with stopgap solutions.
Mr. Oringa Mitro, do you have
Yes, sir.
anything to say on
Yes,
this
sir.
issue?
Yes, sir. Yes, sir. Of course.
Please.
Thank you, ma'am, for the question, and thank you, sir, for referring it to me. Like I already stated, in the course of my submissions over here, that the courts have not, in the perspective of North Bengal, of course, I am not aware of the South Bengal scenario, but in North Bengal, the criminal courts have not been functional. Functional in the sense is some sort of physical filing has taken place, and if you ask for matters being listed for hearing or for orders, that I would like to, most unfortunately, I would like to say that these are not being done. And as Ma'am Upal has pointed out, that is of course a denial of human rights, and it has not taken place. Hopefully, let's see, the local judiciary, they are making efforts to regularize, matters to be taken up from the 1st of September in some places. And I hope from Siliguri will start, dealing with these matters and hearing them and passing orders.
That's so great. Thank you so much. At least people are alive, even if they're going to the courts. At least people are alive and secure that way. So.
Yes, absolutely right. Absolutely right. You see, we are still in an absolutely rudimentary stage of technological acceptance of technology in the matter of disposal of matters in court. So the problem is this, that many of the matters which we want to be heard are not being heard because we are not technologically equipped to handle the matters. That is the problem. Yes. Next question.
If nobody's going to ask a question, may I ask a question, Mr. Mitra?
Yes, please.
Who is responsible
Don't
for...
ask a difficult question.
Thank you. Who is responsible for the infrastructure of IT, setting that up in the courts? Is it the chief minister? Or
no, it is the state government and the Indian government. You see, that is one of the points which have been made by one of the speakers, that the state will have to release adequate fund. That is the most important thing for the purpose of setting up the technological infrastructure which will enable the courts to function normally.
Isn't that something that, again, going back to your wonderful IT, India's wonderful IT people, is that something they would collaborate with, or would they just give the money to the state and say, well, you go away and find out, you procure it?
No, they will collaborate. It has to be collaboration. Without that, the state by itself will not be able to do anything. But the state will have to release the fund for the purpose of the infrastructure to be set up. We are still in an absolutely rudimentary stage in the matter of setting up of the infrastructure. That is the problem now. That is the problem we are facing.
Okay, and that I think there should be calls to expedite that because of the COVID and the need to access justice. I think that those two,
yes,
those
absolutely.
should be bigger points to persuade the government to do that, to release that.
Absolutely. Absolutely. Yes.
Thank you.
Thank you. Yes, any more question?
If I may, sorry, I can't resist it now, but if I may ask, if we want to draw things to your attention, to attention of people, how can we, to colleagues, how can we sort of share that information? Will it come? Are you sort of set up as is there a legal organisation that we can forward information, share information, suggestions?
What kind of information you are thinking?
Well, for example, about the development of human rights, even suggesting sharing information, how it's done here, for example, in the UK. As I said, no man or woman is an island. You learn off other people. It's no good reinventing the wheel when it already exists. So sort of collaboration, intellectual collaboration, forums to exchange ideas, and create awareness. I don't think you've got a formal setup. I found it very difficult to contact the Indian Bar Association to get a response from them. So perhaps if we do it this way, we might be able to spread the ideas and germinate ideas, incubate them, and share with others.
Yeah,
We do a lot of collaboration work here with our regulatory body, which has got various arms and forums including diversity, women's rights, and everyone else's rights. They're quite rightly it's to share information and create. It's educational as well. It'd be interesting. Maybe that's something to look forward to.
Yes.
At a later date. I'll put you on the spot there.
Konkona, if there is no more question, then we can close it.
Thank you.
Thank you.
So there is one small point which I wanted to make, sir.
Yes.
If you may kindly permit me.
Yes, please.
So I was just thinking over one simple aspect, sir. We have got a lot of cases piling up, and we lawyers, once the courts are open, in the lower courts especially, we will just be, herding over there. We'll just be flocking the courts like anything. And I believe, to lessen the burden and also to save the, the scenario, the dangers of, the present dangers. I think if we could bring up a system, the judiciary acts in that manner, that hearings in the lower courts, arguments especially, final arguments of the cases in this lower courts, this should be, put up in the written argument, though the system is still there, but, most of the cases it's avoided. So if it is made mandatory, at least we'll be working in our chambers, preparing arguments, citing decisions, and placing it before the court without wasting the court's time, in the post-COVID situations.
Absolutely correct, Mr. Mitra. In fact, this has been very seriously considered in the High Court amongst the judges. That one of the solutions which the judges have come out with is that in order to cut short the length of a litigation, one can file the notes of arguments containing the evidence, summary of the evidence, and also the legal points, along with the case laws. You can annex them, and if you can file, then perhaps the legal argument can be cut short at least by 1/10.
Yes. Yes, sir.
This is a very good suggestion, and in fact, this suggestion is being considered now very seriously.
Yes.
You see, unfortunately, what is happening now, the situation is such that no long matters are being heard. Only urgent matters and short matters are being taken up, particularly criminal matters.
Yes.
Bail, anticipatory bail. A person is in the jail for the last 3 months or 4 months. His matter comes up. These are urgent matters which are being taken up. But so far, we have not been able to set up the system in such a way as to be able to hear long matters.
Yes, sir.
Matters of evidence, matters of long arguments, hearing of long appeal, we have not been able to do as yet.
Yes. Thank you, sir.
Mr. Mitra, I'm sorry to ask a further question, but
Yes,
I've got the opportunity, so I shall utilize it as much as possible. One of the other things that concerns me is, was very concerned to learn of the number of under trials in India. And obviously, those who are anti-India take full advantage in highlighting that, as did the BBC. They reported the case of a young man, 19 years of age, whose mother had been imprisoned, and it wasn't quite sure that can't remember all the details of the background. Basically, she was in prison, and he was in prison with her because he was there when he was quite young, and he was educated through the prison system. And then when he was an adult, he was obviously released. They had to release him, and then he tries to find out, well, why is his mum in prison? Only to learn that his mum was in prison because she hadn't paid her bail money. So she spent 20 years or something, near 20 years in prison because she hadn't, you know, paid her bail money of $283 or something ridiculous like that. And that causes embarrassment to a great nation and to your legal system, quite frankly. What can be done? I mean, my organization, we provide free advice and legal representation. We would like to help those people because you know that is definitely a gross abuse of human rights, and it is
I agree.
delayed justice. So what's been done? What can be done? We certainly are here to help, but we can't keep coming over and representing each individual. But we are prepared to help, and this is where your legal clerks come in, junior lawyers come in. You know, I don't know because I can't gauge from the information I have how good the pro bono and the sort of what we term as, and quite rightly, charity work is a culture exists in India or not.
I don't think we do have that category of people called charity clerks, but we have got plenty of NGOs,
Yeah.
non-governmental organizations, which take up the cudgels, which take up the causes of these people, and they move the court. You see, unfortunately, madam, our problem is the dearth of judges. You see, so long as you don't have sufficient number of judges to handle these cases go on rotting in the file. And when these matters come up, already 5, 10, 11, 12 years have passed. And it's a crying shame. I agree with you. It's a crying shame that we have to face this kind of allegation. And our judicial system is not being able to meet that particular state of affairs.
Okay, well, this is where we come in. We are fortunate that we can do this, but I don't know how to contact these people, the victims, shall we say, those people who are in prisons waiting, and we can do something about that. But we would need like the help of legal clerks or junior lawyers out there, and we're quite happy to do that. So again, I would like to share that information with all the lawyers present and get that information out there, and we'll definitely do something about it. Because if it comes out, it hit the headlines, and then again, it's bad adverse publicity for India, and there are people who want to do that. But I'm not in that game. We are offer genuine because our organisation is about human rights. We don't earn any money out of it. We just want to do the right thing because that's a huge amount of money, people who are denied access to justice and to their human rights.
Yes, I mean, I think we can work it out. I do not know. I can't tell you just off the cuff, but
no?
I think we can work it out. We can sit together and we can find out some solution. I think there are organizations which do take up this kind of thing. Perhaps with whom I can put you across so that you can talk.
If I may say something here, sir.
Yes, Shayo.
There are definitely organizations such as the Human Rights Law Network in India, as well as other organizations which deal with such issues. And I think that if you were to reach out to Ms. Uppal, if you were to reach out to such organizations such as HRLN or other such organizations, you would find people who are willing to volunteer their services. In fact, DPON is involved with Commonwealth Human Rights Initiative, which also deals with such issues and also does a great deal of work towards that extent. And I think there's a lot many people who can work towards this and ensure that the positive result is reached.
Thank you very much, Mr. Chakravarti. I would definitely reach out to them, but we don't like waiting. We just deal with it. We value the urgency. So I'm more than happy to work with people and create that sort of awareness. We can invite people over to England when it's possible to give talks on these, because I think that's what needs to be done. It needs to be exposed that these people do exist. and that they require help. But perhaps we can contact each other by email. I'll leave my email here should anyone wish to contact me.
Yes, ma'am. I've also put in the email where you may contact and get in touch with the CHRI.
That's great. Thank you very much, Mr. Pakar.
Okay. So
I think we are towards the end of it.
Yeah.
Yeah. We can wind up. Thank you so much, Advocate Mitra, for your observation and your valuable remark on the proposed topic. I would like to thank all the distinguished speakers for being with us this evening and their enriching deliberation. Thank you so much, Advocate Uppal, for joining us right from Britain and sharing your observation, discussing. I think today's webinar enable us to acknowledge various vital issues that if addressed would ease the challenges of the functioning of legal forum during such unprecedented circumstances. I would like to thank all the participants or the audience for being with us this evening. As you know, Institute of Social and Cultural Studies, as a part of its imperative, have been doing a lot of activities, and addressing various issues. We have certain forthcoming events and activity also coming in. So to know more about it, keep scrolling through our Facebook pages, keep connected and stay connected. Till then, stay safe and good night. And thank you all for being with us. Thank you. Good night.
Thank you so much. Thank you, sir. Thank you, ma'am. Thank you, everyone.
Thank you, everyone. Thank you, sir.
Bye.
Thank you all. Thank you.